Hello and welcome to what shall we call this? iCrossing's Olympic briefing. I really feel I should be holding a javelin, not a microphone, and or maybe strike a pose like Usain Bolt. Probably not. It doesn't work for me, really, does it? With the 2012 Olympic Games just around the corner, the UK is really set to reap the rewards of hosting the Games and receive a very welcome boost to its economy. Hosting the Games presents a once-in-a-generation opportunity, not just for British athletes and the sporting bodies, but also for wider British business. It's an opportunity to capitalise upon the expected increase in consumer expenditure and wider positive impacts such as increased output, productivity and job creation. A veritable financial halo is expected to be generated by the Games. Clearly there are immediate opportunities for retail, travel and leisure brands, but also legacy effects which will go much further to influence many other verticals. Right now, retailer Marks & Spencer's brand new 150,000 square feet store on the Olympic site in Stratford is doing incredibly well, bettering the performance of many of their flagship city centre stores, and that months ahead of the Games. There are a few early downsides too. The same retailer has experienced a £500,000 drop in trade when an Olympic cycling trial and event test trundled down the high streets of its Surrey stores and diverted footfall. Kind of interesting data indeed. And if you indulge me for just a moment, I'd like to share with you some more mind-blowing numbers, and I need the iPad to remind me of some of the statistics. It's estimated during the period of the Games, consumer spending will increase by £750 million, with a predicted increase in economic output of £1.1 billion. In the 3 years immediately following the Games, it is forecast UK economic output will increase by £1.87 billion per year, providing a total stimulus to the economy of £5.1 billion. In those 3 years, an additional 18,000 jobs will be created each year, generating additional household income of £296 million per year. Specifically during the 7 weeks of the Games themselves, the increase in high street consumer spending is likely to reach £185 million. Yes, Christmas really will come early on the high street next year. There is also likely to be a £123 million increase for the hotel sector, £82 million increase for the entertainment, food and drink industry, and a £40 million increase for airlines, car hire and wider travel sectors. For the 3 years after the Games, the legacy effect is expected to generate an additional £235 million per annum in consumer spending on the high street, £151 million increase for hotels, £102 million increase for entertainment, food and drink, and more. It's clear that there are many opportunities available around the Games, but how can brands maximise the return on this potential, and what are the key pitfalls to avoid? One of the key pitfalls to be aware of is the complex legislation and stringent regulation surrounding the Olympic brand and its use. In today's session, we'll focus on this area and provide some guidance for brands wishing to exploit the opportunity. So without further ado, and thankfully for me, no more statistics to quote, I would like to introduce consultant solicitors Julian Caudle and Oliver Smith from Keystone Law, who are going to help provide some further information as to the opportunities available for brands and those things to be aware of. Do please welcome them.
Right, hello. My name's Julian Caudle and this is Oliver Smith, and today we're going to give you a talk about ambush marketing in general and specific things around the Olympics, the event which is happening next year in London and various other places. Ambush marketing, which you may or may not heard of, is a kind of marketing activity, a technique where somebody sort of piggybacks on an event or a team or an individual at the expense of somebody else's association with it. The point being that by doing this, these people get a commercial and a marketing advantage, basically at the expense of those people who have entered into official sponsorship or official partner agreements with the event organisers, and have paid significant amount of money to have rights to associate or to market using the logos and the marketing paraphernalia and things of that particular event. So it's a sort of protection for those people who have invested in it in order to get marketing collateral out of it. The other point about ambush marketing and why it's kind of dealt with and tackled in the way that it is that event organisers will say that actually by ambush marketing it basically dilutes the value of these official partnerships and official sponsorship arrangements, and therefore potentially if a lot of it goes on, brands will not see any value in entering into and paying significant sums for exclusive rights when everybody else is doing it as well. So there's potential that ambush marketing techniques can actually affect the viability of events which rely to a large extent on money raised through official sponsorship and promotion arrangements. So that's what ambush marketing is. We're now looking at a few examples of ambush marketing, which will give you a bit of an idea about the type of things which ambush marketing, the definition, covers. In 2005, for example, people were stopped going into Wimbledon carrying Palmolive branded free water, which was handed out to them in the queues outside, because the official sponsor of the event was Buxton Water. So they didn't want people, on TV, in the press and things, holding Palmolive branded water. Bavaria beer is quite a serial offender at this kind of things, at least as far as the World Cup is concerned, in quite a humorous way. In 2006, Bavaria beer, which is interestingly is a Dutch brand and has orange branding. They had a number of spectators at a World Cup event who were all wearing orange branded, Bavaria branded lederhosen, and they were all forced by the stadium officials to remove the said lederhosen before the game started, so then ended up watching it all in their underwear. Not to be sort of stopped from doing this, Bavaria then went back in the 2010 World Cup, and you may remember the orange mini dress clad ladies who were all incredibly photogenic, who all appeared in a large group at one of the matches. I mean, it was everywhere in the press, all wearing orange mini dresses, very small Bavaria logos, but again they were told to leave the stadium. Again, it was physical ambush marketing. One I particularly like was, again, World Cup 2010. The Kalula airline, which was not an official partner of the 2010 World Cup, advertised itself as the unofficial national carrier of the you-know-what in advertising, which was covered in the colours of South Africa, vuvuzelas and everything else, and stadia and what have you. And very amusing, but again, obviously, ambush marketing. And finally, in the Ryder Cup, so just to show that it's not just all World Cups and Olympics, in the Ryder Cup, Paddy Power erected a 270-foot billboard just on the boundary of the course, which they were then forced to take down. So basically, these are all activities, and it's gone on for years and years. The Los Angeles Olympics was quite a famous example. It's gone on for years and years, but it's basically brands promoting themselves in areas and making themselves associated and look like they are connected with that event, sponsors or partners of that event when they're not. Now, the general law on this is the usual IP laws that you have. I mean, in the UK, there is not, with the exception of the ones we're coming to, there are not any specific ambush marketing or anti-ambush marketing laws or legislation. So you have to basically look at the usual stuff. So basically, the event organisers would be looking at bringing cases of passing off against a brand who engaged in this activity. In order to do that, they would have to show that they had the event organizer had a sort of reputational goodwill in that event, that the third party had misrepresented themselves in some way, which leads to the public being confused as to whether there is a connection between that brand and the event. And the event organizer has to actually have suffered damage or be likely to suffer damage. Now, passing off is the one that's probably most often used together with trademark infringement when dealing with ambush marketing. But passing off is quite a difficult action to bring. It has quite a high, burden of proof, I suppose you'd say, but it's quite difficult. It can be quite expensive. It's not an easy action to bring a passing off action. The other one is trademarks, and regardless of the specific legislation we're going to talk about now, all these things also apply, so don't forget about all these things. Trademark infringement, using somebody else's trademark, on your goods or in relation to your services without authorization, on the whole is trademark infringement if it's a registered trademark. The Olympic rings are a registered trademark. London 2012 is a registered trademark. I think 2012 itself is a registered trademark. So don't forget about registered trademarks, because that's an easier action to bring in some ways if there's not any specific legislation to deal with it. There's also issues about copyright infringement. So logos, for example, would be protected by copyright. So if you copied the logo, used the logo on something, that would be copyright infringement. And also potentially design infringement for things like, perhaps things like the mascots might be a registered design. Again, there's another issue there that if you use those when you're not authorised to do so, in some cases you could be liable for those. So those are the usual forms of legal protection which are used in various combinations to deal with ambush marketing. There's also sort of practical protection, which people perhaps don't know quite so much about, which event organisers use. And these are particularly things like contractual obligations. So, for example, an event organiser would have contractual obligations with stadium owners for things who are going to host events as part of that event. For things like only allowing the official sponsors' drinks to be in there, so-called pouring rights. There would be perhaps naming things for the stadium. You'd find that quite often in football stadium anyway. That's why they changed their names from what they used to be known to the Emirates or the Etihad or whatever else it might be. These are all to do with sponsorship agreements. So there is often a web of specific contracts between the event organisers and the venue hosts, and also contracts between the official sponsors and the official partners and the event organiser, enforcing the event organiser to do certain things. So making sure that the event organiser will go after people who are passing off or trademark infringement. So there are all those things as well, which help to kind of try and get a grip on ambush marketing. Actions by event organisers, even if they're not contractually bound to do so, you'll find that quite often they will buy up, or their agency will buy up all the outdoor advertising within a certain radius of each of the event venues, in order that only official sponsors or only official partners can advertise on there. So they will do certain things like that. Also, there's agreements with athletes and participants about what they can and cannot do. So there will be stuff about, because of course athletes will have their own sponsorship arrangements for their kit, for their footwear, for all kinds of things. And then when you go to you go to Olympics or whatever it might be, they might be an official clothing or an official footwear supplier there. So there was an instance, I think it was Linford Christie, I can't remember now, where he had some contact lenses or something which were branded with his own the brand which he was associated with, which was not the brand which the games he was at was associated with. So that got into trouble. So there's contracts with the athletes to make sure effectively they behave as well, and also one which is is also dealt with specifically in legislation, but is also dealt with under contractual terms, which is to do with tickets. I mean, tickets, particularly things like FIFA for the World Cup and for the Olympics, which is specifically covered. Tickets are generally not transferable. You can't use them for competitions. You can't use them for promotions. You know, all these things are basically what in legal terms we would say is right out. So you can't do any of those things. So that's the kind of general framework which would apply all the time. You know, this is not specific. This is the general rules, and they just apply to ambush marketing in the way that they apply to any marketing. Now, however, as we said, there is no specific UK anti-ambush marketing legislation apart from specifically for the Olympics, and there are two, and there is also some regulations which are coming in, which I'll touch on briefly, but I haven't done in great detail in the talk. But these are to do with the Olympic symbols and the London Olympic symbols, if you roughly put. So there is a 1995 Act, which is the Olympic Symbol Protection Act, which gives what's known, creates what's known as the Olympics Association right, which I will, on the next slide, tell you about. This has been in place since 1995. The proprietor of this right is the British Olympics Association, and since the 2006 Act, also LOCOG, who also jointly own this right. There is a Paralympics Association right that came in 2006, and then there's a specific London Olympics Association right, which also came in 2006, which is the one that a lot of the controversy has been about. So the Olympic and, well, I'll lump together the Olympic and Paralympic Association rights. These are, as we said, operated by, owned by LOCOG and the British Olympic Association. The British Olympic Association has, you know, quite a history of enthusiastically enforcing these rights. But basically what it says is that they have exclusive rights in respect of the use of the Olympic symbol, the 5 rings, the Paralympic symbol, which apparently is the 3 agitos, or agitos, I'm not quite sure how that's pronounced, and the words Olympic, Olympiad, Olympian, and the Paralympic, Paralympiad, and Paralympian, and their plurals. And finally, the mottos of both the International Olympic Committee and the International Paralympic Committee, which are in the Latin, faster, higher, stronger, which is the Olympic motto, and Spirit in Motion, which is the Paralympic motto. Now, basically, what it says is that any use of these in the course of trade is not permitted. And also bear in mind that, for example, the Olympic rings are also a registered trademark, and they're a registered trademark in every single class of goods, at least throughout Europe and probably in most other places as well. So you just cannot use the Olympic symbols in the course of trade. However, since 2006, they've widened this. So it was quite certain that you just, you know, there were these things and you can't use them. So fine, we know where we are. However, since 2006, they've also added that it's an infringement to use something that is so similar to these as to be likely to create in the public mind an association with the Olympic Games or movement or the Paralympic Games or movement. And that came in 2006 with the Act, which also brought in the London right as well. And our association is very wide. It includes anything contractual, commercial, corporate, or any structural connection at all. But so those are similar things to these. So I think, you know, you'd find it kind of easy to work out in terms of the words. The mottos might be a bit more interesting, you know, the words spirit and things, and we'll come on to those a bit later. But there are very, very limited exceptions. There are some very limited exceptions to where you can use these things. There is a general exception, is that you are allowed to use them if it's not likely to suggest an association, because the whole point is it's supposed to be a right which suggests an association. But that can only be in the context of some kind of honest practice, and you can't be really making any promotional commercial use by incorporating it in a context which is where the Olympics is largely irrelevant. So it allows things for saying like, well, I've got a flat which I'm renting, which is 5 minutes from the Olympic Park or something like that. But it doesn't allow you to say Olympic Park flats, and then 20 miles away or something like that. So it's to do with context, I think. But the Olympic and Paralympic Association right, I think, is reasonably easy to deal with. What is not quite so easy to deal with is the London Olympic Association right. Now, this was brought in 2006, the 2006 Act, and created somewhat of a hoo-ha in the advertising and marketing community due to the width of it, the breadth of it, and the somewhat uncertainty of it. LOCOG is the exclusive proprietor of this right, and basically the Act says that they can prevent others from making a representation of any kind, and note the of any kind bit, in a manner likely to suggest to the public there is an association between that person or their goods and services and the London Olympics. And London Olympics means the Paralympics as well for these purposes. So that's use of representation of any kind. So if you think back to the Olympic Association right, that was quite specific about symbols, mottos, and words, and the words Olympian and Paralympian, etc. But the London Olympic Association right is wider than that, or very much appears to be wider than that. Now, there's a lot of guidance on it, but the Act also has something in it which people were very exercised about. In the Act, it basically says there are some words and expressions which the court might take into account to decide whether there had been an association. And there's basically two lists of words. So if you use any two words of List A, and List A is Games, 2012, 2012, or 2012, so any two of those, or any one of those, and any one or more of these, London, medals, sponsors, gold, silver, bronze, summer, then a court might look at that and say, well, you're creating an association in terms of your goods or your services, your marketing. The one thing that did happen during the course of this Act was that when it was going through, under the Olympics right, there is a presumption if you use these things that you've infringed. So if you use the Olympic rings, you have to basically say that you haven't been making an association. The presumption is that you have. LOCOG wanted the same thing to apply to this, to any representation at all, that the presumption, and that didn't go through because it was considered to be too restrictive and too difficult, due, I think, probably to the width of this right and its uncertainty in application. So now all it says is that the court might take these into account, and I don't think a court has been in a position where it's had to take them into account yet, so we don't know how that's going to work. There is a lot of guidance on the London 2012 website about the London Olympics Association right. There's a link there. There is also another document which is much bigger. It's about 61-page PDF called Statutory Marketing, which has lots of examples of things that LOCOG believes that they won't infringe and things that they believe will. And those are quite interesting. Some are very obvious and some are not. But in that document, it still goes on to suggest other things which LOCOG would view as infringing. So not just these lists. In the depths of this document, there are also other things that they think of. So obviously, the use of the Olympic torch or flame, for example, a representation of that. An advert with athletes in sort of national kit or something going past an Olympic venue, for example. That kind of stuff. And also things around use of words such as spirit, endeavour, friendship, winning, determination, those kind of things, which are what they claim to be Olympic qualities, again might suggest an association as far as LOCOG is concerned. Also the use of 30th or the Roman numerals 3X's because it is the 30th Olympiad, again, might suggest an association. The difficulty is that you have to look at the thing as a whole, as to whether the marketing material as a whole, when looked at, given the elements in it, suggest an association between the Games or the Olympic movement. So it is quite difficult, and to work out which side of the line you're on. I mean, it's quite easy to work out when you've got it absolutely wrong. I mean, it's very easy to work out when you're right. You really are in infringing territory. What's difficult is there's going to be a sort of grey area in the middle, which is going to be very difficult. So that is the London Olympic Association right. One thing I haven't mentioned on here is, you will have heard probably in the press, there are some advertising and street trading regulations, which are, the consultation period has just finished, and DCMS have just come out with their response to it, which you may have heard various discussions about streakers having branding on them, and people letting pigs loose with company corporate branding on them in the Olympic Park and various other things, and all these things are going to be covered. So basically, during the Games, there is going to be an event zone, an event period, which are basically clean zones. So several hundred yards around the Olympic, the venues in the Olympic Park, you are not, people are not going to be able to advertise in any way or market in any way, unless they're permitted to do so by LOCOG. And that includes things like in the air, that includes the use of animals, that includes, things on people's clothing and things on people's bodies, all kinds of stuff. And there is also going to be a clean zone in terms of street trading as well, with certain exceptions, i.e. for the people who already street trade there at the moment. So there are basically going to be these clean zones, but they're just not round the venues in the Olympic Park. There is also, you've got to bear in mind things like the road cycling. So there will be clean zones around the pavements by the road cycling. I'm not quite sure how it works in terms of the sailing and the rowing, and when they release this legislation, it will have all these event zones and the periods for which those areas are effectively clean. In terms of the Olympics itself and the Olympic Park, it'll be 3 weeks. For the Paralympics, it'll be 2 weeks. And for some of the other events, often it's the day before and the day of the event. So they're not for a very long period, but they are very, very stringent. And they will be enforced by various people, including potentially the police. So those are other things to bear in mind.
My name is Oliver Smith. I'm an intellectual property dispute resolution lawyer with Keystone Law. I wanted to say a few words about the practical enforcement of the Olympic rights if you're unfortunate enough to get caught up in that machinery. LOCOG's approach is that they try to resolve matters informally, but they have a conflict in that they also want to keep their sponsors happy. So that they come back to sponsor other events and so on, and that they get value for money, and that they honour their commitments to LOCOG, financially and otherwise. So just picking up on something that Gillian said, before I go through all those downsides of being involved in Olympic marketing, the key question from what Gillian said is, or two key questions are really whether there's a similarity between what you're doing on behalf of your clients or what your clients are doing and the Olympic rights and the trademarks, and also whether there's an association. And that will be tested objectively, both between lawyers arguing about it and if it ever ends up in court. But I think one of the important things to remember is that anything you do on behalf of your clients, if it's permanently recorded, it will all become disclosable in any litigation. And one of the first things they will look at is what was your intention, even if it wasn't objectively against the law. Going through the sort of downsides of being caught up in the enforcement machinery, the first most pressing thing will be the threat of an injunction if you don't cooperate with LOCOG. what they'll normally do is they'll phone you up or they'll send you a letter saying, we've been told, probably by one of their big sponsors, that you or one of your clients are conducting a campaign and they're very upset about it, that it infringes every right under the sun, and they want you to stop it immediately and tell them exactly what you've been doing, tell them who your clients are, how much money they've spent on it, where all the other examples of your campaign where you're planning them to appear, so that they can then write to all the media organisations telling them not to cooperate with you. So this potentially can cause massive disruption to your business, to your relationship with your clients. They'll get very upset. They probably won't want to pay you. They'll probably threaten to sue you. It'll be really bad for your reputation if it gets out into the trade press or the national media. So it needs to be managed carefully. And I think the key to it is, obviously you need some advice, I would say that, but you also need to basically move quickly and cooperate and act reasonably. So you have to take the advice about whether or not what you're doing is actually an infringement of the Olympic rights or whether it's actually on the right side of the line. You could, in the worst case scenario, get an injunction arriving on your desk or in your email inbox without you even being aware of it, because in the very extreme cases, say for example you're just about to launch some massive advertising campaign and there's literally only a few hours to go before it's broadcast, they might just go straight to court, get the injunction, serve it on the broadcaster and on you, and then argue about it all later. So the first thing you'll know is, half an hour before transmission, you'll be contacted by the broadcaster to say they're not going to run your ads because they've just been injuncted and you need to get your lawyers involved. And obviously your clients will be very upset about that, and it'll need to be dealt with quickly to try and limit the damage, try and get the broadcast back up if you can, or just come to some sensible deal. On a sort of small scale, even if you accept that you've made a mistake and put your hands up, if they've gone to court to get the injunction, they're going to expect you to pay their costs, which are going to could easily be £5,000 to £10,000, because they'll have produced reams of witness statements and documents showing how important the Olympic brand and rights are, and how awful it would be if you were allowed to do anything that vaguely infringed them. If you get into that situation, the next thing they're going to do once they've stopped you is to ask you to pay some damages and their enormous legal costs. And assessing damages can also be a bit of a legal nightmare, because there are a number of different ways that the court can decide how much damage has been done to the Olympic movement or to their sponsors. The most common is what's called a reasonable license fee, and that's basically is a very potentially wide-ranging exercise. The most famous and what lawyers would call the leading case on that is a case for the Formula One driver Eddie Irvine. I was involved in the appeal of that, and TalkSport Radio, under the stewardship of Kelvin McKenzie, decided to take a photograph of Eddie Irvine. I think it was in the pits at some Formula One race, and he was on his mobile phone, and they doctored the photo to make it look like he was listening to a radio which had a big TalkSport logo on the side, and they sent that to a whole load of media buyers. It was supposed to be a joke, but I think it slightly backfired, because Eddie didn't see the funny side of it and spent a lot of money suing over it. And TalkSport's argument was that this was only a small thing. They just sent it out to 30 or 40 media buyers, and they would never have spent any money on it. And they succeeded in the High Court, but in the Court of Appeal, the justices accepted that basically Eddie Irvine's evidence was that he wouldn't have got out of bed for less than 20 grand. And so Eddie won, but it wasn't really about the damages. Of course, it was about the legal costs, which were probably nudging £1 million. So that was a pretty expensive mistake, and probably a few people lost their jobs over that. So one needs to be pretty careful. An account of profits in theory, they can have an account of the profit you've made out of infringing their rights. In practice, it hardly ever happens because normally they say that the damage to us is much worse than whatever profit you made out of it, and so they have to choose one or the other. So they go for the damages. There are provisions in the various advertising codes that are enforced by the ASA and other bodies to make sure that advertisements are legal, decent, honest, and so on. And potentially, if you've infringed the Olympic rights, then you will probably fall foul of those codes as well. So even if they don't take you to court, they can still disrupt your business by getting the ASA involved. And if you ignore the ASA, it used to be difficult for them to do very much, but now the Office of Fair Trading can actually go to court and get a court injunction to make you observe the ASA's codes.
On the whole, this is, the legislation is often brought in, as you say, for sporting events. I mean, there are plenty. South Africa, New Zealand, I think, did it for the Rugby World Cup. So, but all those ambush marketing issues, if we take the specific Olympics type or sporting legislation out of the equation, all those points I made about trademarks, about passing off, about copyright design infringement, all of those kind of things apply generally. So, for example, I guess one you would think of would be certain music events, maybe. So particularly where things have sponsors.
One thing that people often forget about, because most of the rights are very clear. If you want to know what a registered trademark is, you just go onto the UK Intellectual Property Office website and look it up, search against the name of the company. But copyright, people often forget about because it's not registered, and it comes into existence when somebody creates something that's original and of value. Then they often overlook that, and particularly in photographs, people just think there's a photo on the web, it's on their website, I'll just take a copy of it and put it on something else, and they'll always get you for that. And the amount of money involved is not really very much in terms of damages, because most photographs, unless they're super amazing, are only worth a few £100s. But then you get into a whole fight about whether it's an infringement or not, and before you know it, you've spent thousands on legal costs. So you just have to be really careful about cut and pasting photographs from the web or wherever.
The thing is that, advertising and marketing is not going to stop. It's not stopping it. But the question is that you have to think about the advertising and marketing you're going to do, and particularly in some ways when it's done, because it's all to do with context particularly. Obviously the stuff about the Olympic rings and things, are right out. But I'm sure that already. That's not a problem. I think most people are aware of that. But the London Association right in particular is so potentially wide-ranging, and often it's, even if you don't use those listed expressions, it's to do with context. So I think, obviously it's not going to stop advertising and marketing next year because that's ridiculous. But there are things to look at. Do look at that statutory marketing, plough your way through the local guidance.
I'm really interested, I suppose, in the London Olympic rights, which, as you've said, that there's quite a grey area. Quite a lot of what we do as a business involves a lot of copy and content, sometimes short snippets in search marketplaces, sometimes quite extensive content. Is there really a danger of saying things like you two can go for gold in 2012 by eating this low-fat yogurt? Is that a no-no?
Yes.
Okay. Even when you have phrases like going for gold, where really, the Olympics does not have a monopoly on gold medals. Lots of the sporting events do have that.
Well, again, it's about the association. These lists are things which the Act says that the court might take into account. Those lists of those specific words, the gold and the 2012 in London and medals and whatnot. Originally, it was supposed to be that there would be a presumption that if you'd used those words in combination that you would have infringed the right, and there was howls of protest about it. So again, it's just something the court might take into account, but then the court might take into account a lot of other things as well. Use of Olympic torches and whatnot. But in your yogurt example, you've got going for gold in 2012 with said yogurt. You've already got two of you've got one from Group A and one from List B in there already. So I mean, I think you're struggling there, because that is clearly, in my mind, is an association with the Olympics, and making it look like there is an association between that brand and the Olympics.
I think obviously it depends on what it makes people think when they see it, because that's the test. It's it's the perception of your marketplace, your viewers, your readers. What will the average person seeing that think? Will they think that you have some association with the Olympics, or you're trying to make some association with the Olympics, or is it just an innocent promotion that plays on the values of sporting excellence and human virtues? And judges are no fools. They'll know just from reading it what they think your intention was, or what objectively what the marketplace or the consumer would think. And then they'll dig behind all the background to how you got to that, to try and figure out whether your intention corroborates what they think the objective interpretation is. I mean, I think from a practical point of view, there's nothing wrong with patriotism, and that's probably the best thing. That's the bandwagon you should be jumping on rather than the Olympic one, because there is specific mention in a lot of the low-cog material about not wishing to stop people being patriotic.
So there are ways round sort of the sport element, the health element, as long as you negotiate it quite carefully. And the patriotism element. I mean, although Team GB is another thing which is not something that you should be using, it's something they specifically mention as either as a trademark or a passing off right over that. So, but yeah, it's difficult.